National Forestry Act 1984, the plaintiff was issued a use of permit for compartment 82 Bukit Sungai Puteh Forest Reserve, which is the land where the plaintiff built a telecommunications transmitter station and the tower onto the property. The plaintiff has the valid license held under the Communications and Multimedia Act 1998. In a letter to the defendant, the plaintiff offered to move the tower, which concealed a portion of the research forest. The State Director of Forestry sent a letter revoking the use permit on 18 May 2018. The State Forestry Department extended the deadline for the plaintiff to remove the latter's movable property. In December 2018, the defendant presented the images showing the employees from multiple telecommunications providers disassembling their facilities and equipment from the tower. Defendants demolished the tower in January 2019. By enclosed 18, the defendant made an application under Order 48 of the Rules of Court 2012 for the determination of the following question of law for disposal of suit without a full trial, whether the plaintiff has a cause of action and/or the right to claim compensations for the demolitions of the subject matter telecommunications tower erected on forest reserve land in light of the effect under the NFA 1984 of the use permit had been revoked.
The issue in this present case is whether the present suit is suitable under Order 14A disposal by determinations of the questions of law for disposal of the suit without the full trial. After considering the affidavit and submissions of the parties, the learned judge has satisfied that the undisputed facts are sufficient for determinations of the state questions of law, and that an answer to the state questions of law will dispose of either a whole or a substantial part of the suit, and can result in saving of cost and time.
Order 14, Rule 1 of the Rules of Court is the determination of the question of law on construction. In Kerajaan Negeri Kelantan vs Petroleum Nasional Berhad and other appeals, Federal Court emphasized that Order 48 procedure is inappropriate and not suitable in the case where there are severe factual disagreements. The court will look into the undisputed or admitted facts, where Order 48 can only be resolved if there is no disagreement between the parties regarding to the relevant facts, or the court decides that the material facts were not in dispute. This can be seen in the case of Tay Hotel vs Muhammad Afrizam bin Hussain, where all the material facts concerning to the subject matter of the claim must be undisputed or admitted in order to rely on Order 48, and it cannot be invoked based on the presumption facts. Next is the court will look into the suitable question of law for construction. Order 48 is inappropriate or not suitable when a question of fact is invoked. This can be seen in the case of Director of Forest, Sarawak and Anna vs Rector and others, and other appeals, where the judge referred to the commentary of the Order 48 appearing in the Malaysian court practice, where whether all the necessary and material facts relating to the subject matter of the question have been duly proved or admitted. The suitability of disposing of an action under this order depends entirely on whether the court can determine the question of law rests without a full trial of action. While in the case of Mahkamah Jamata Lawatni, where the plaintiff filed an application seeking a decision on the preliminary issues of whether there was an issue on estoppel.
Moving on to the analysis, the questions of law in this current case is regarding the local standard of the plaintiff to claim for compensations. There is no explicit evidence required and no dispute on the questions of fact. Furthermore, the application has been entered at an interlocutory stage. By referring to the case of Dayabi, it seems to be the perfect timing to file the applications of Order 14A. Apart from that, the requirements have been clearly listed under Order 14 Rule 1 Sub 1. Firstly, the questions of law in the current case is suitable for determinations without the full trial, as the material facts relating to the local standard of the plaintiff was undisputed facts. Secondly, the issue of local standard represents the fundamental questions that can determine the entire case, whether or not the suit shall be initiated in the first place. Thirdly, both parties has been given the opportunity for being heard, as they have given a suitable date to set down for hearing date. On a final note, in consortium case, it highlights that the determinations of the questions of law enable the disposal of the suit under Order 14A at the interlocutory stage without a full trial, which will lead to a cost-saving and time-effective outcome. There are three prerequisites that must be fulfilled before the court proceeds to determine the questions of law.
In this case, the plaintiff was Elite Agriculture and the first defendant was Hajime. Elite was the registered lessee for 99 years over land. Hajime and the other defendants were the occupier of the said land. Elite claims that their representative have been prevented by the defendant from entering the said land, and Elite thus invoked the summary procedure under Order 89 of ROC because the defendant refused to deliver the vacant possessions of the land. But the defendant contended that the land was part of the customary land of the Samalai people. The High Court judge rejected such contentions and granted summarily a vacant possession order to the plaintiff. The defendant not testified and filed an appeal on the ground that, first, the Order 89 does not apply to the case where the land has been occupied before the title was issued. Second, the National Land Code recognized the customary right to occupy the land. And third, when there is a dispute on whether the land is subject to customary right, the action should be a writ action and not the originating summons under the summary procedure.
Good day, madam. My name is Xian. The main issue for us to discuss in this case was whether the originating summons under summary procedures of Order 89 of the Rules of Court can be invoked to evict the occupiers of the land in the case where there were tribal issues of law and fact. The Court of Appeal held that this dispute could only be resolved at the trial begun by a writ actions and not via a summary procedures under Order 89. And thus the High Court judge shall not summarily grant an order for evictions. Eventually, the court dismissed the case with liberty to the plaintiff to file a writ action. Order 89 is a summary proceedings for possessions of land, which provides solutions to the shortcomings of the ordinary writ procedures in the case of evictions of trespassers. However, this order could only apply in the circumstances where the land is occupied by the person who entered the premises without the consent of the landowner or without the consent of the person who claims the possessions, but not to the person holding over after the determinations of a lease or tenancy. In Salim's case, the court held that to entitle a defendant to a trial, all he needs to do is to show that there is a triable issue of law or fact. It is only in clear cases of trespass that a summary order can be made under Order 89. The court in the case of Chu Wing-Wah and Li Wei-Chong also hold the same view that the summary order under Order 89 can only be sought and granted if there are no real issues that require trial. For example, in the case of Teka Urus, the land was occupied with the acquiescence of the state government. Hence, the court found that the case could not be dealt with summarily under Order 89 because there were triable issues which should be determined at the trial. Furthermore, Order 89 also could not apply in the case where a person has occupied the land with the consent of predecessors in the title of the person who claimed the possessions, as what was shown in the case of Vitromax. The judge in this case also said that the plaintiff should have taken a writ actions against the defendant if it feels aggrieved by his entry or occupations of the premises. The same decision was also held in the case of Farad Uga, where the court observed that the appellant had demonstrated an arguable case that they could occupy the lands with the acquiescence of the predecessors in the title of the respondent. This has raised several triable issues which could not simply be dealt with under Order 89.
It's noted that Order 89 could not apply in the case where there are tribal issues. In the present case, the defendant argued that the land is the customary land of the Samalai people. Their customary rights were recognized by the state government, the state director of land, and the registered proprietor before the title was issued. So the presence of the defendant was also known by the chief minister of Pahang, which is very similar to the Taka Urus case. And this portrayed that there were somehow arguable issues to be determined, and if there are arguable cases, then it is deemed to have tribal issues. Thus, Order 89 cannot be sought. In Vitromax and Farad case, the occupations of the land was done with the implied consent of the owner of the land. This is similar to the current case. The defendant has been occupying the land for at least 6 generations, and their continuous occupations of land received no actions from the registered proprietor. This shows that there was somehow implied consent given by the owner. This makes the issue more complex and cannot simply be decided in the summary proceedings. The defendant identity also has been strongly argued, which render that there is no way in which the dispute over the identity and the prior occupations can be resolved other than through a trial begun by a writ action. So all the facts in the current case portray that there are multiple issues of facts and law that are tribal, and thus Order 89 cannot be invoked. To conclude, what we learned from the case is that Order 89 provides a legal recourse to evict the unwelcome guest. However, this summary proceeding shall not be invoked unless the case demonstrates that it has no triable issues that can merit the trial. So we are in line with the decisions held by the Court of Appeal to dismiss the originating summons on the ground that they are triable issues, with liberty given to elite to file a writ actions. That's all from us. Thank you.